The story starts here at Bethany City Church, Hendon on Monday the 5th of June 2017, an open event organised by Sunderland MP Julie Elliott. Mr. Ian McCready was not only refused entry, he claims he was assaulted by Councillor Essel and Julie Elliott's secretary Mr. March. Mr. McCready informed them he would be reporting the incident to the police. Within hours a screenshot of his Facebook page had been taken and words inserted onto the screenshot. This fake document was sent to the police by Councillor Miles Elliott, the son of MP Julie Elliott. The words added to the screenshot of McCready's Facebook page: "Well, I am sitting here wanting to go to Sunderland Labour office and kick the shit out of one of her staff." The next day the police attend McCready's home and inform him he's going to be investigated for sending a malicious threatening communication to Miles Elliott. The police then send their evidence, the fake document, to the Crown Prosecution Service, CPS, who agree to prosecute McCready. Charges. On the 5th of June 2017 at Sunderland sent to Miles Elliott an electronic communication, namely a Facebook message, which conveyed a message which was indecent or grossly offensive for the purpose of causing distress or anxiety to the recipient or to any other person to whom you intended that it or its contents or nature should be communicated. Contrary to Section 1(1)(a) and 4 of the Malicious Communications Act. On Friday the 15th of December 2017, McCready attended Sunderland Magistrates Court and his solicitor had the fake document examined. The case was then adjourned until Friday the 12th of January 2018. McCready called his solicitor on the 8th of January 2018, a few days before he was summoned to attend court. He was informed the case had been dropped. This was confirmed on Friday the 16th of February 2018. 8 months of stress due to a fake document being given to the police and CPS. Since that date, McCready has campaigned for confirmation recognition that the document given to the police by Miles Elliott was indeed a fake document proving his innocence to all. The police have refused to investigate the origins of the fake document and defended Miles Elliott by sending him this letter which he posted on social media, causing McCready even more stress. Dear Mr. Elliott, it has been brought to my attention that there have been a number of posts on social media which states Miles Elliott committed perjury. These posts relate to the discontinuance of a prosecution for an offence of malicious communications against a male by the name of Ian McCready. I have looked into the circumstances of this case and I would like to reassure you that the case was discontinued as a result of failings in the police investigation following the submission of a defence statement by Mr. McCready. I have no reason at this time to doubt that the evidence provided by yourself in relation to the case was accurate and provided in good faith to assist the police, and would reiterate that the discontinuance was a result of failings in the police investigation. I hope the above outlines the reasons why this prosecution was discontinued and apologize for the failings of the police investigation into this matter. This letter was posted on social media by Miles Elliott and caused further media abuse of McCready on a scale that he became frightened to leave his home in fear of attack. He contacted his solicitor to get a better understanding of why the police were still stating the evidence was accurate, supporting Miles Elliott. On the 8th of March 2018, McCready's solicitor replied with a written explanation.
As requested, I have completed a timeline in relation to the offenses you faced in 2018. Charged originally back in 2017, you first were charged to appear at South Tyneside Magistrates Court on the 31st October 2017 in relation to allegations of malicious communications which is alleged to have been conducted on the 5th June 2017. The nature of that offense is that you are alleged to have sent for the attention of Julie Elliott and Miles Elliott a post on your Facebook which was derogatory in nature and designed to fuel unrest at a meeting of the Sunderland Labour Party. The nature of the Facebook message, as you have seen, and was essentially the words Ian McCready, "Well, I am sitting here waiting to go to the Sunderland Labour office and kick the shit out of one of her staff." The nature of that communication is of an inflammatory nature and one which suggests the use of unlawful violence on a public office worker. You emphatically denied that you were responsible for posting those words, and the case was listed for trial. In essence, The nature of your defense is that the posting that you had originally put on Facebook had been screenshot and amended using Microsoft Word to utilize the words that were put on the piece of paper that was presented to the Crown Prosecution Service, and this did not accurately represent any post that you had put on your own Facebook site. The inference from this was that somebody had doctored the posting unlawfully with the intention of either perverting the course of justice to secure an arrest and conviction against yourself in circumstances where you had not committed any offense. The case proceeded through the magistrate's court, and we requested certain documentation from both Miles Elliott and indeed people who had provided that alleged post to Miles Elliott through the police, requesting access to their computers so that we could identify who, if any, of the individuals concerned had in fact changed the post for purposes of obtaining a conviction against yourself. We can confirm that the police seemed to have requested the information from both Miles Elliott and allegedly the person who presented the document to Miles Elliott, and they refused to assist the police in providing access to their computer systems. This subsequently resulted in the notice of discontinuance. In other words, the prosecution dropped the case against you on the basis that they could not answer the queries that we had raised and were not in a position to confirm whether or not any person had in fact altered the post and acted in a manner which intended to pervert the course of justice. Consequently, the prosecution had no choice but to discontinue the case against you. This does not, however, amount to any assertion that Miles Elliott or any other person has acted in a criminal fashion. This simply means that the prosecution could not be certain that you had posted the words allegedly on the Facebook site. They could not be certain that they had sufficient evidence in which to prosecute you, and it left in the air the suggestion that somebody else, unnamed, had in fact altered your post and presented a false document to Miles Elliott. In answering the question that you have put to us, we cannot make any suggestion that either Miles Elliott or any member of his staff have gone to the extent of altering any posts made by you. There is no evidence to suggest that this has been undertaken either by Miles Elliott or under his instruction, and we would caution you to be very careful as to any suggestions that you make in that regard. The only thing that you can actually be certain of is that the prosecution could not continue with the proceedings against you because of the questions that have been raised, and were not in a position to be able to prosecute you fully. I hope this correspondence assists you and makes it clear as to the reasons why the case did not proceed. You have effectively been found not guilty of the offense because of the notice of discontinuance, and consequently, the proceedings will not resurface against you.
McCready is still facing media abuse, mainly posted on Miles Elliott's Facebook page, including lies and deceit from Miles Elliott and Graham March. Why haven't the police investigated the origins of the document? Surely it's in the public's interest to discover the truth, considering the fact that Len Lowther is now being prosecuted for assisting McCready expose this travesty of justice. A former police chief superintendent was approached by McCready for assistance. He wrote to the police EPS and the Independent Office of Police Complaints about his concerns following his comprehensive examination of evidence, to no avail. He has also written a witness statement for Len Lowther's trial, but when Lowther presented this witness statement to the judge in a pre-trial hearing, the judge told Lowther the former police chief superintendent would not be allowed in his court.
Part of the witness statement, quote, "Upon my own comprehensive examination of the evidence against McCready, it was clearly my view that despite the two-stage test for prosecutors, namely the evidential and public interest tests, that the evidence presented by police to the Crown Prosecution Service for decision was woefully inadequate. There was insufficient evidence to proceed with a case against Mr. McCready. I could not understand how such a decision had been arrived at by the CPS, and from an investigative perspective, it was obvious that the case presented to the CPS by the police was well below the standard expected of the police in my view. In essence, the case against Mr. McCready was centered upon a document purporting to be a screenshot of a Facebook comment from McCready of a threatening nature against a member of the Labour Party. On examination and quite simple investigative process, it was clear that the allegation that the said document had been published through Facebook was entirely untrue, and this should have formed the basis of the investigation by Northumbria Police, which was incompetent and failed to follow quite basic investigative principles such as following the rules of establishing continuity of evidence. For example, the investigating officer failed to determine the source of the alleged offending document and relied solely on evidence provided by the witness Miles Elliott, without sufficient scrutiny to determine the truth. No evidence had been sought from Facebook, which would have identified very quickly that the style of the alleged offending material could not have been produced on Facebook. From documentation examined, it is clear that Northumbria police failed to follow a logical line of inquiry in Mr. McCready's case by investigating the possibility that Mr. Elliott and or Mr. March had made up the document subject of Mr. McCready's initial charge. As highlighted above, the basic investigative principle of establishing continuity of evidence has been overlooked by Northumbria police, and the advice apparently offered to the OIC for a failed investigation was not good enough in my opinion and should have been resumed by way of further investigation into what was a serious offense. There are no statutes of limitations for perverting the course of justice. A person can be prosecuted after many years for perverting the course of justice.
Ian McCready will never get justice until Northumbria police investigate the origins of the fake document, and Len Lowther is likely to get a jail sentence for supporting McCready. It is a conspiracy involving the MP Julie Elliott, Police and Crime Commissioner Kim McGuinness, Dame Vera Baird, the Chief Constable Winton Keenan, and the Labour Party. Save Sunderland, vote anything but Labour.